Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. And today, I will be discussing a rather small topic, which is the different kinds or the types of goods under the Sale of Goods Act. The different kinds or the types of goods under the Sale of Goods Act can be classified as existing goods, future goods, and contingent goods. Existing goods. Existing goods are the goods which physically exist and which are owned or possessed by the seller at the time of making the contract of sale. Sometimes the seller may not be the owner but may be in the possession of the goods. An example of such situation is an agent. In case the goods are not in existence, then there cannot be any contract of sale. For example, A sells his horse to B, believing the horse to be alive, but in fact the horse was dead at the time of making the contract. Here, there was no contract at all. Existing goods may be further classified into specific goods, ascertained goods, and unascertained goods. Specific goods. As per Section 2, subsection 14, specific goods mean goods identified and agreed upon at the time a contract of sale is made. To be specific goods, the goods must be actually identified, and it is not sufficient that the goods are only identifiable. For example, A owns a number of cars. He promises to sell only one of them to B. Here, the goods are not specific because it cannot be identified. However, if A promises to sell his only black colored Maruti car, then the offer is valid and this is known as a specific good. Ascertained goods. These are the goods which are not identified or ascertained at the time of making the contract of sale. They are defined only by description or by sample. Those goods that are not specifically agreed upon at the time of entering into a contract are known as ascertained goods. For example, Mr. A owns 20 dogs. B enters into a contract with A to buy only one dog. That one dog is an ascertained good. That is, out of a huge number of dogs, some or even one is separated from the rest. And finally, unascertained goods. These are the goods which become ascertained after the formation of contract of sale. For example, there are 100 leather jackets out of which Mr. A has agreed to purchase 10 out of 100 leather jackets. But Mr. A has not decided which 10 leather jackets he is going to purchase. These 10 jackets are known as unascertained goods. The second classification of goods is future goods. These are the goods which a seller does not possess at the time of making the contract, but which will be manufactured, produced, or acquired by him after making the contract. They are the goods that are yet to be manufactured. Unlike existing goods, the future goods are not in existence at the time of contract of sale. A contract of sale for future goods creates only an agreement to sell and not a sale. For example, A agrees to sell B all the rice which is to be grown in his field in the current season. This is a sale of future goods and it is only an agreement to sell. And the last type of classification is contingent goods. These are the goods similar to future goods. In this case, the acquisition of goods by the seller depends upon a certain contingency or an uncertain event. They can be only an agreement to sell and not a sale. The contract of sale of contingent goods can be enforced only on the happening or non-happening of a specified uncertain event, or otherwise the contract itself becomes void. And with this, I come to the end for today's session. And in tomorrow's discussion, I will be talking about condition of warranty under the Sale of Goods Act. Until then, stay safe and have a great day. Thank you.